Good morning, everybody. Thank you all for joining us. And I think we have all made it in from the waiting room, so we're going to go ahead and get started today. Thank you again, like I said, for joining us today for the Condominium Law Group Zoom Q&A. We are happy to have you with us today. I'm going to start with our normal Zoom housekeeping and tips and requests like I do every week. And I'll start by telling you that we do ask that you stay muted during the Zoom unless you would like to unmute yourself to ask a question. You're welcome to do that, of course. But if you could otherwise stay muted, that helps minimize background noise. You'll find your mute and unmute button along with your start and stop video button and other buttons for the Zoom, wherever your Zoom toolbar is located, maybe at the bottom of your screen. And the chat button or the chat function might be flashing because I just put a message into the chat. The chat is the best way to ask questions or ask us to clarify anything that we've said today. So if you have questions that you would like us to try to cover, feel free to pop those into the chat. We will just remind you that, which we do every week, and you guys are all very well behaved, so we probably don't even need to say this, but briefly, just a reminder that we do like the chat to be limited to that use only, questions and requests for clarification, not for legal discussion, argument, commentary, etc., like you might see on the CAI message boards. Another thing that we remind everybody about last week is that we are here to give general legal information only, not legal advice. So if you submit a question either by email in advance or in the chat that is very specific and is asking for advice, we're going to tell you that we can't answer the question. We can't give advice in this forum. If the subject matter is broadly applicable or helpful to community associations or managers or people in this community, then we'll try to cover it generally when we can. So if you find yourself about to send a question where you feel like you have to copy and paste from your governing documents, or you're sending us 2 or 3 paragraphs of detail about your question, it's probably too specific and it's probably a request for legal advice. And so you can just keep that in mind as you're considering what questions to send our way. It's probably no surprise to everybody that we continue to get a lot of questions about the Corporate Transparency Act. I want to give you guys just a little bit of additional information. I'm going to remind everybody that it is still being challenged by national CAI, and we think it is still reasonable if a community wants to wait for a few more weeks before starting to take steps to comply with the CTA. The latest date that a community association can file its beneficial owner information report and comply with the CTA is currently December 31st of this year. So the statute says you have to have filed that report before January 1st, 2025. I find that to be confusing language. You need to get it done by December 31st in order to be in compliance. There was a hearing on a motion for a preliminary injunction in the lawsuit that CAI National filed about the CTA, and that hearing took place last week on October 11th. We are hoping that the court will grant the motion for a preliminary injunction. And if the court does grant that motion, what that will likely mean is that community associations will not be required to comply with the CTA pending the outcome of that litigation. We don't know how quickly we'll get the ruling on that motion. It could be a week or two, it could be several weeks. Federal courts are not always the fastest. But as soon as we do have a ruling on that motion, we will let you all know. However, until then, I think it's reasonable just to assume that you're going to have to comply until somebody tells you otherwise. We noted, I think last week, that several law firms and management companies are offering to file the BOI reports for their association clients. In some cases, there are some pretty significant fees attached to that service. And I think that boards can do this themselves. Like I shared a couple of weeks ago, had to get my own FinCEN ID number as an individual in preparation for our law firm filing our own CTA report. And it took me, I'm not kidding, under 5 minutes. I think it was probably under 2, but that's because I already had a login.gov login and password. So the same password that I use to log into my personal IRS account and my TSA PreCheck account is the same one that you log into and then apply for a FinCEN ID number. Each board member can go apply for their own individual FinCEN ID number, and then all they have to give the association, the board as a whole, the manager, whoever's filing the report, is that ID number. And then the manager can go, or the board member filing the BOI report can go to the website, start a report. There's 4 sections. They're relatively brief. You fill out the report, including those FinCEN ID numbers for your beneficial owners, which is primarily your board members. And then you submit the report online. It's not difficult to do. It's just going to take a little bit of time. It's a little bit annoying, but it's no more difficult than filing with the Secretary of State for your corporation to begin with. So keep that in mind. If you have additional questions about the CTA, what it requires, who is subject to it, spoiler alert, it's all of you. You can look at our Q&A video from October 9th, which is linked on our YouTube channel, which is in that message that I put into the chat. We did go a little bit more into detail on October 9th. Like I said, that was last week. And just start getting your ducks in a row to prepare for compliance before the end of the year. And if anything changes, we will tell you as soon as we find out about it. It's also worth mentioning very briefly that if you want sort of just a 30,000-foot view and some general information about what the CTA requires, if you go to condolawgroup.com, that's our blog URL. And the most recent blog article is about the CTA and compliance with the CTA. One other reminder before we jump into the questions is that it's time, it's budget time, and all the managers on this Zoom are like, girl, you're not telling me anything I don't know. You guys already all know this. But those of you that are in self-managed communities, might be a little bit less aware of the timeline required in order to properly ratify a budget. If you want to increase your assessments on January 1st, 2025, you need to be putting your budget together now so that you can send it out to your owners, comply with the notice that is required in the statute for ratifying a budget, and hold your ratification meeting before the end of December. And nobody wants to be doing that stuff during the holiday season. So again, if that's something that isn't on your radar yet, it should be. And so you should be providing enough time to get your budget ratified before the end of the year. Again, if you want to raise the dues on January 1st. If you don't care about raising the dues on January 1st and you're fine with that increase going into effect in February or March, you have a little bit more time to plan. And for anyone who's not aware, the statute that is relevant to ratifying a budget is RCW 6490-525. It is a section of WUCIOA that applies to all associations and has applied to all associations in Washington state since it was enacted on July 1st of 2018. So if this is news to you, go check out that statute. The nice thing is that it's basically a checklist for everything you have to do and provide to your owners in order to properly ratify a budget and get that process going. Jennifer, unless you have anything to add on the announcements, I'm going to jump into the questions.
I think we're good to go.
Okay. All right, here's the first one. I am looking for some advice on handling a situation where the association board approved a decision that is in violation of the association's governing documents. Specifically, the board recently approved an ACC request to allow Christmas lights to remain up year-round, despite HOA guidelines that prohibit it. This decision was made without a formal board meeting and seems to conflict with the association's rules. As the management company, should we simply document the board's decision for our records, or is there a recommended course of action when the board's approval conflicts with the association's governing documents? Appreciate any guidance on how to handle this professionally and in line with our role as managers. So I think the first thing that I need to say, even though I just gave the disclaimer about not giving legal advice less than 5 minutes ago, is that I cannot answer this question for any specific situation. So this is not an answer to what you, individual manager who submitted this question, should do about the Christmas lights in this particular community, right? But I think we can talk generally about 2 questions here. The first is, what is the manager's obligation, or what can or should a manager do when a board makes a decision that's inconsistent with the association's governing documents in one way or another? I think there's a lot of different things that you could do, and it probably depends on the facts and circumstances. I will admit that when I was reading this question, I was thinking, well, in the scheme of sort of bad board decisions, letting somebody keep their lights up year round is pretty low on my list of things that I think is bad, right? We have all seen or at least heard stories about boards who make far more egregious decisions, even though the vast majority of boards are doing their very best to comply with their association documents. So I think this is a really minor issue in my opinion, but all of that being said, sometimes the issues might not be minor. As a manager, you might be looking at a board that is inconsistently enforcing the governing documents, or maybe they're sending delinquent homeowners to collection, but they're not sending a delinquent board member to collection, right? There are definitely more egregious board decisions that are not in line with either statute or governing documents. But I think as a starting point, one thing you can do is advise the board of the inconsistency. They might be unaware of it, so you help make sure that they're making an informed decision. And if it is something that rises to the level of requiring or suggesting that this might be helpful, ask them to get more information or advice from professionals, right? Lawyers, accountants, arborists, city code enforcement officer, there's a wide variety of experts that an association board can rely on when making informed decisions. So depending on the type of decision it is that you think, I'm not really sure they're doing the right thing there, you can advise them to get more information and advice from their team of experts. You can also advise the board on any risks that you see that might come along with the decision that they're making. And you can document their decision in a set of board meeting minutes, which is where all board decisions should be documented. And if they made a decision outside of a board meeting, then you probably should tell them that they need to ratify it at their next meeting, and so that decision is reflected in the minutes. All of that being said, I think in general, managers have pretty low risk associated with board decisions that are contrary to the governing documents. In particular, when the board is properly informed by the manager of that potential risk. Every management contract I've ever read has an indemnification provision in it. And so I think your risk as a manager when a board is making decisions that are not in line with the governing documents is pretty low. And I think that list of suggestion covers this part of the question. The other question is, are boards allowed to make decisions that are inconsistent with the written documents? And I think the answer to that question is sometimes they absolutely can. And in fact, in certain situations, there is specific statutory authority allowing them to do that. So there are circumstances where a board might make decisions that are contrary to the governing documents. So for example, if you're accommodating a disability on the part of an owner, that might lead you to do something that is not consistent with your governing documents. If you are making a decision to comply with state law of one kind or another, depending again, in particular on how old your documents are, that might be contrary to the governing documents. And in addition, especially when it comes to enforcement, WUCIOA specifically recognizes and grants boards the authority to be selective in their enforcement as long as it is not arbitrary and capricious. So if you go to RCW 6490-405, that is the powers and duties section of WUCIOA, subsection 7 reads that the board may determine whether to take enforcement action by exercising the association's power to impose sanctions or commencing an action for a violation of the governing documents, including whether to compromise any claim for unpaid assessments or other claims made by or against it. So the board gets to determine whether to take enforcement action. So I think, again, going back to what I said in the beginning, I think that as a manager, your role is to inform the board of what you're seeing in a given situation, document the board's decision properly, and beyond that, you're certainly your authority to limit or change what the board is doing. You don't have that authority. It is the board that gets to make decisions on behalf of the association. So I think that's about as far as you can go. Jen, did you have anything you wanted to add to that one?
No, I don't.
Okay.
And moving on to the next question. Following up on the CA Day seminar, it was mentioned that any assessment, fee, or fine will require a hearing. Does this include uninsured portions in the case of a loss? And does this affect all community associations now? And then the answer to that is for UCIOA communities, yes. The statute is 6490 480 subsection 7 and 8. An opportunity for a hearing is required to assess for the uninsured portion of any loss, but that's only for community associations under UCIOA now. It's not applicable right now to condos and HOAs that are not UCIOA communities, but it will become applicable January 1st, 2028. That's when all the other statutes drop off, and UCIOA is the only statute for community associations in Washington state. So the best practice is to get into the habit right now of giving notice and opportunity to be heard before assessing any fines or the uninsured portion of a loss. So some declarations may have other requirements under the old statutes, but under UCIOA, only some losses can be assessed to the source unit. The new statute, and that's the 6490 subsection 7 and 8. The new statute requires negligence by the source unit, which is different than what many older insurance amendments and insurance language says. We don't think UCIOA allows for strict liability anymore. So if you have language in your governing documents that states that an owner is responsible for damage up to the association's deductible for failure of components that they're responsible for, we don't think that that language is going to be allowed anymore under UCIOA. So just to recap, if you're a UCIOA community now, yes, that applies. In 2028, January 1st, it will apply to everyone. So best practice is to get into the habit of doing it now. Valerie, did you have anything to add?
Yeah, the one thing I will add is, speaking to strict liability, I agree with Jennifer that strict liability is no longer allowed under the language within WUCIOA. And one way, or one, I guess, illustration of that is WUCIOA limits the ability to collect for damage caused, for example, by a high-risk component. If the language to do it has to be in your governing documents. You have to give notice and an opportunity to be heard, but it also says that your documents have to make it clear to the owners that failure to comply with, for example, a replacement schedule for water heaters has to tell them that if they fail to comply, they might be liable for costs related to damage caused by that component. So this is just something to be aware of. Again, this doesn't apply to most communities now. It just applies to WUCIOA communities now. But because it's going to apply to everybody, it's something to become aware of, understand the parameters of, and get in practice with. And one other thing I'll offer from the perspective of somebody that often handles collecting delinquent assessments for our clients, the number of times that we have a ledger come to us where the owner is paying all of the monthly and all the assessments on time, and the only delinquent balance due is some kind of repair charge, deductible charge, or whatever that's been added to the ledger, and a year of penalties has then been added to that underlying amount due, only for us to then review the documents and tell the association that either they didn't have the authority to collect that amount against the owner at all, or that they failed to follow the procedures for notice that are required under their governing documents or their statute if they're a WUCIOA community. I would say the vast majority of the time that a ledger comes to us with that kind of charge on it, the association is not able to collect it for one reason or another. So you just want to make sure that you are understanding what's allowed and what's required and doing things right from the beginning, so that you don't have an attorney like me tell you 18 months later, sorry, you can't collect it because you did this wrong or you don't have the authority. All right, I'm going to move on to our next question. Can you point me toward anything on the internet to support the change I was just told about, that Washington only does secret ballots for budget ratifications and special assessment ratifications as of June 2024? So the only statute that currently requires secret ballots for anything is WUCIOA. That was a change that took effect earlier this year, and it will obviously apply to everybody in 2028. But for right now, this is applicable only to WUCIOA communities. And the statute is RCW 6490-455, and it's subsection 9. And it provides that provides for secret ballots for association votes. And I want to clarify that association votes. There's no secret ballots when it comes to board voting, okay? Association votes on the election of board members, the removal of board members, amendments to the declaration or governing documents, and the approval to reallocate a common element to a limited common element. Secret ballots are not required for budgets or special assessments. So that is the statute that you can look up online. Again, it's RCW 6490-455, subsection 9. And again, it's only currently applicable to communities that are governed by WUCIOA. And that will be true for everybody come January 1st, 2028. Jen, did you have anything to add on that one?
I don't. Sorry, I'm trying to answer something in the chat. So moving on. The next question is, can draft budgets be reviewed and voted on by the board using majority approval? So the statute that applies is 6490-525. This is applicable to everyone since July 1st of 2018, when WUCIOA first became effective. So the language under that particular statute states that the board approves the budget by majority of quorum, then sends the budget to the budget disclosures to the owners for ratification. So the board must review and vote on the draft budget, and then it's only submitted to the members for ratification after the board approves it. So I really don't have anything to add to that. Valerie, did you have anything?
I think it's a short question, and if the person who submitted it, if there was something else you were trying to get at, if you think we're misunderstanding the question, feel free to ask for clarification or provide additional detail in the comments. Next question. If an association has a lake and the lake waters rise and create damage to an owner's property, who is responsible to remedy the situation? I think as a starting point, I have to say that this is not a question that we can answer in this forum for many reasons, including the fact that we don't give legal advice here, and also including that some of the answers to questions like this are very governing document dependent. So it might depend on what your declaration says and what your maps say about boundaries, etc. That being said, it also depends on whether the lake rose because of natural conditions or whether the association took any action to cause the water levels to change. If the change in the water levels is from rain or weather or some other natural condition not caused by the association, then it's less likely the association has any obligation to remedy the situation. Water flowing naturally is actually considered something called a common enemy. That's the actual term used by the courts. It's called the common enemy doctrine. And only if a person or entity like the association modifies the natural flow of water would they be more likely to have liability. I'm trying not to talk in absolutes here. So again, you got to check with your association attorney to find out if the lake in this community rose, who has to do what, because it depends on a lot of things, including what caused the water to rise, what do the governing documents say, what do the maps look like. And then if this community does not have an attorney, then they should get one so they can get competent advice on this question. Jen?
Nothing to add. So the next question. Our condominium documents from 1997 authorize the board to hold regular, special, and organizational meetings and require it to keep minutes of board meetings or meetings of a committee authorized to act on behalf of the board. We are being told that the board is holding working sessions every other month, and those are not meetings, and therefore no announcement or minutes are necessary. The Finance Committee includes a quorum of board members, but there are no announcements or minutes of those meetings. May our condominium board hold any type of meeting whenever, wherever, and however it wishes, and keeps minutes of only those meetings it wishes, as our board president has stated. So we get questions like this a lot. And my note is, a meeting is a meeting is a meeting. So please feel free to go onto our YouTube channel and search the, excuse me, the channel for secret meetings or working sessions, because that question has come up as well. So one particular caveat here is that there's no requirement to hold open meetings under the RCW 6432 or RCW 6434, the condominium statutes. So if you're a condominium not under UCIOA and your documents do not require open meetings, then your board isn't required to hold open meetings. It is a best practice, but it's not required. So that's one thing to keep in mind. If the board holds a meeting, even a working session, and votes to take action on something, that action must be reflected in board meeting minutes for it to be known to everyone and for it to have that record of what happened. If there is no record, then there's no way to determine when or how that decision was made. So if you disagree with how the board is operating, you can start campaigning, get yourself elected to the board. You can see if there are enough owners to agree that this is a practice that shouldn't happen, to try and get a recall of either particular board members or the entire board. You can contact an attorney specializing in common interest community owners. There are some who practice on the owner side. We practice on the association side. You can always just move. So this is a really nuanced question. It really depends on what's in your governing documents, what particular statute you're under, although in 2028, all of that goes away and all associations are required to hold open meetings under UCIOA, because that statute will be the only one and that would control. But until then, unless your documents state otherwise, for condominiums only, that you're not required to hold open meetings. Valerie, did you have anything to add to that?
Nope, that covers it. I'm going to jump into our next question regarding BOI again. And just to clarify for everybody, BOI is beneficial owner information. It is the type of report that's required under the CTA. The question says, it was stated by condo law that 501c4 social welfare is the only exception to not being required to file a BOI. Is a determination letter for a 501c7 social also an exception for not requiring to file a BOI? So I really should just say, I can't answer this question for you because you're asking for legal advice about whether your association has to comply with the CTA if you're a 501c7. And so I need to be very clear that this answer is general in nature and it is not an answer to your specific question for your specific community. The CTA does not appear to make an exception for 501c7 organizations. And I'm going to actually copy and paste a link into the chat, which is for FAQs related to the CTA. This is on the FinCEN website. And if you just do Control F in your browser, once you get to this website and search association or HOA, it'll take you to the page or the part of the FAQs that talk about homeowner associations. And it makes it really clear that almost all of the time, only a 501c4 association, which provides public parks or amenities, provides services to the public, is the type of association that might qualify for an exemption. In other words, the vast majority Like none of our clients are going to qualify for an exemption to the CTA, to the reporting requirements under the CTA. So I can't speak for any specific community. The IRS also has very clear guidance that no HOA or community club that serves only its members can qualify for a 501c4. In other words, you have to serve all of the public in order to qualify as a 501c4 organization. So beyond what we've already shared about the CTA earlier today, you all know that there was this hearing last week. Maybe there's going to be an injunction that delays the implementation of the CTA when it comes to associations. All of that stuff we've already covered. I don't want to repeat any more of that. But if you're trying to find out if your social 501c7 association has to comply with the CTA, you need to ask your association attorney, because we can't give you an answer to that question in this forum. But also, I think my answer is one that you wouldn't like, which is I think you still probably have to comply. And also, I'm just going to keep reminding everybody, it's not that hard. I promise you. If you guys are on this Zoom right now, you have the technical competence to go to the CTA website and file the CTA report for your community. You're not giving the government any information that it does not already have. When I filed for my individual FinCEN number, all I did was I happened to have my passport right here next to my desk. I took a snapshot of the, like the page with my photo and all the passport information. I uploaded that. It took like 3 minutes. I got my FinCEN ID number. And one of the most common objections that I keep hearing from people over having to comply with the CTA is that they don't want to give the government their personal information. And what I said at CA Day a couple weeks ago was, they already have your personal information. Who do you think issued your passport? It's the federal government. So you're not giving them any information that they don't already have. And I promise you, it is easier than you think it is. So sorry, I'm going to stop ranting now, but that's the end of my answer to that question. If you have anything to add, Jennifer, feel free.
I don't. The next question is, does an association have to budget for all items in the reserve study when preparing the budget for the upcoming year? So the answer here is, it really depends on what you're asking. So if you have reserves that are adequately funded for the work that needs done in the upcoming budget year, then you're probably fine. If your reserves are adequately funded, you would not include anything reserve related in your operating budget, because the funds for the reserve related expenditures comes out of the reserve fund, not the operating budget. If your reserve fund is not adequately funded and you need to repair or replace a reserve component in the upcoming budget year, you would need to account for that in your regular budget or adopt and ratify a special assessment to pay for that expense. Your normal budget would also include line items for however much of this year's income is going to be put into the reserve for reserve fund expenditures in the future. So the budget should include enough going into the reserve account to pay for projects due in the next few years, as well as save money for future projects based on whatever projection was given to you by your reserve specialist. You don't have to budget as if everything will need to be replaced in the upcoming year. So if the question was, do we have to have our reserve fund fully funded every year, or budget as if we're going to have to replace everything in the upcoming year? The answer is no. But you should have enough going into your reserve fund to pay for projects that are upcoming in the next year, next couple years, as well as starting to save for future projects, so you don't need a special assessment to pay for those expenditures. Now, statute only requires that you have a reserve fund. It doesn't require that you have anything in it. But having a reserve fund, an adequate reserve fund, means that you're more likely to have to be able to get commercial mortgages. Mortgage companies are being much more careful in how how and who they're lending money to. Because of inadequate funds, we've had at least two that I am aware of, associations not have deals fall through to purchase units because of inadequate funds in their reserve. So what you are required to do, and I saw your question, I'll get to it in a moment. So what you're required to do is have a reserve fund, and yes, Lee, it does need to be a separate account. You're required to have that separate account, but you're also required to have a reserve study to tell you how much you should be saving, how much your delinquent isn't the word I'm looking for, how much you're under what you should be saving or overfunded.
Surplus or deficit.
Thank you. I don't deal with this often. So, well, I deal with the concept, I don't deal with those terms. So how much your deficit is, because God knows the vast majority of our clients are underfunded. And then on a per unit basis, how much should be paid to make up that difference. So reserve specialists are giving you a projection. They're giving you their best guess on how much you should be saving. It's you don't have to actually do that. It's highly recommended. And mortgage companies are now being much more careful in how they're looking at this. Valerie, did you have anything to add to that?
The one thing I'll add is that if you are a WUCIOA community, but also for everybody looking forward to 2028, RCW 6490-535 not only specifies that an association may have to establish a reserve fund, but it also says any reserve account must be an income earning account maintained under the direct control of the board, and the board is responsible for administering the reserve account. So that's just something to keep in mind. If you are not a WUCIOA community yet, it's something to be planning for, come 2028, that the reserve account has to be under the direct control of the board. So I'm going to go ahead and move on to our next question, which is a short and easy one. Are resale certificates required for all condominiums? The answer is yes. I could just leave it at that, but I will also give you the statutory citation, which is RCW 6434-425, which is part of the Condominium Act. But under the applicability section of the Condominium Act, that section also applies to old act condos. And of course, resale certificates are required for all WUCIOA communities, whether they are condominiums or HOAs. So if your community was formed after July 1st of 2018, regardless of what kind of community you are, you have a resale certificate requirement. If you are a condominium of any kind, you have a resale certificate requirement. It might be easier just to say who doesn't have a resale certificate requirement. And currently that is only communities governed by the HOA Act, which is RCW 6438. So that's that. Yes, all condos have to do resale certificates, and starting in 2028, everybody is going to have to do resale certificates. So that's another thing to keep in mind for that upcoming change. Jen?
Okay, next question. At our condominium annual owners meeting, where there are director positions and other matters to vote on, can owners be given the option of attending the meeting and voting in person, or simply returning a completed and signed paper ballot without attending the meeting? The answer is yes, as long as there are no nominations from the floor and all voting issues and candidates are listed on the ballot. So there are specific requirements for voting by ballot. And you can find it in 6432-280, 6434-340, 6438-120, 6490-455. So 6490-455 sub 2 sub C. Whenever proposals or board members, thank you, Valerie, are to be voted on at a meeting, a unit owner may vote by duly executed absentee ballot if the name of each candidate and the text of each proposal to be voted on are set forth in a writing accompanying or contained in the notice of meeting, and the ballot is provided by the association for such purpose. So in a nutshell, the answer is yes. There are certain requirements required by statute. This is one of the statutes that the legislature put in every single community association statute. So as long as there are no candidates, no new proposals from the floor, all candidates are on the absentee ballot prepared by the board, all issues for voting are on the absentee ballot prepared by the association, you're good to go. Valerie, did you have anything to add to that?
Nope, I think you covered it. All right, our next question. I have a condominium and they have a homeowner that got an electric vehicle and has been charging their car in the garage, but the garage's electricity is paid for by the association. We have seen a significant increase in the electric bill since they started doing so, but because the bill is for the whole building, we don't have a way to verify that the increase is due to them charging their vehicle. I know that we have to allow EV charging, but could the board vote and add an EV charging fee to their rules and set a flat monthly fee for homeowners that want to charge their vehicles in the garage to go towards increased electric bills? So I think I have to start by saying this is too specific to answer, and some of this will depend at least in part on the current language in your declaration when it comes to shifting costs to individual unit owners. Beyond that, though, while statutes do require associations to allow EV charging stations under certain circumstances, they do not require associations to allow owners to just charge their car from common element electrical outlets. So we do believe that electrical code requires a dedicated electrical circuit, which a plug in your garage probably wouldn't be. And statutes allow reasonable restrictions on EV charging stations, and requiring an owner to pay the cost to charge their car seems like it would be reasonable. So I think what we would recommend to any particular community in this situation is that you hire your attorney to assist in drafting a set of rules or an EV charger policy that is consistent with the new statutes for electric vehicle charging. And the statutes state that the association does not have to approve an EV charging station unless the owner agrees to pay for the electricity. So for example, you can look at RCW 6490-513, subsection 4E for an example of that language. But I think the moral of the story is here a couple of things. You don't have to let somebody just plug their car into a regular outlet to charge it at the association's expense. But you can't ban EV charging altogether in your community. And if you're considering adopting a set of rules around both charging electrical vehicles as well as the installation, payment for, and maintenance of EV charging stations, you definitely want to consult with your attorney before you adopt and publish that policy to your owners to make sure that you are not acting in a manner that's contrary to what is required and allowed by the statutes. Jen, did you have anything to add?
Just briefly, for most people, they're aware Ken used to be a contractor, and he suggested that if this is a association garage, the board or the association can just turn off the power to that particular part of the garage. If it won't cause any other issues, that is something you can do. Otherwise, if it's a single garage assigned to this particular unit and the unit owner is using association power, you can try to turn off power to that particular plug. I don't know if that's feasible, but it's something to look into while you're doing this. He did point out that we have a couple other communities where the board entered into an agreement with the particular owner who was charging to pay a certain amount every month for their use of the association's electricity. And also one thing that he pointed out is that if you have one individual charging and then another individual trying to charge their vehicle either from the same outlet on that circuit or either from that outlet or a different outlet on the same circuit, it will blow the breaker. So there could be other issues involved with charging from just a regular plug other than the use of electricity. So that's something that the board should look into as well. Valerie, did you have anything?
No, but we do have a couple of questions in the chat, so I think we can jump into those. One of them is there a requirement for a management company to hand over association funds like there is for association records? Yes, there is. And this is actually one of the things that is going to be changing for all communities because of WUCIOA. And Jen, if you want to jump in with any of the existing statutes right now, you can, while I look up the change, because WUCIOA now imposes a pretty strict timeline for turning over records and funds when there is a management transition.
I'm not sure that the current statutes do.
Okay, so check that. I can speak to the WUCIOA change. So 649495, which is the record section under WUCIOA, subsection 9 says, an association's managing agent must deliver all of the association's original books and records to the association upon termination of its management relationship with the association, or upon such other demand as is made by the board. Electronic records must be provided within 5 days of termination or the board's demand, and written records must be provided within 10 days of termination or the board's demand. An association managing agent may keep copies of the association records at its own expense. There is some negotiation going on with the legislature because there's a WUCIOA trailer bill is what we're calling it that is being negotiated right now for the upcoming legislative session that will seek to make some modifications to WUCIOA as it currently exists. And one of the things that perhaps might change somewhat is the timeline here, because I think there's a recognition that 5 to 10 days is relatively quick. I think the reason that this was put in there is because the legislature recognized that there have been scenarios in which the turnover of records was unreasonably delayed, and they wanted to address that situation. But I think the bottom line as to your question about association funds is the money belongs to the association. So absolutely, there's an obligation to turn over the association funds when there's a management transition. Most management contracts provide for some sort of holdback and a period of time for a holdback like that, so that if bills, are come trailing in, that your management company has an obligation to pay for the association, that there are funds on hand to allow the management company to pay those bills, but it has to be limited. And so if your management company is administering the operating account, for example, for an association that transitions, the vast majority of those funds should be turned over as quickly, in my opinion, as the records should. I don't know if you have anything you want to add to that, Jen.
Just briefly, I took a look at 6434 because some sections of this apply to 6432 as well. There's nothing in the record statute regarding how quickly the records must be turned over. But there was something, we had a question earlier regarding, do reserve funds need to be in a segregated account? The answer is yes. So that is 6434-372 sub 2. Any reserve funds of an association shall be kept in a segregated account. Any transaction affecting such funds, including the issuance of checks, shall require the signature of at least 2 persons who are officers of the association. Officers or directors, I'm sorry. But just because the statute requires dual signatures of board members doesn't mean banks do. And in our experience, the vast majority of banks don't even look to see that the checks are even signed. So as a manager or as a management company, if your practice is to have the boards authorize the manager to issue funds out of the reserve account, you can probably do that. It's reasonable. It just depends on how much risk the board is willing to take.
Thanks, Jen. All right, we have another question from the chat. What can be done if someone in a condo adds a new bathroom to their unit without permission from the association some years ago? Permits were likely not obtained. I think the answer to this question is too specific for us to cover in the Q&A. It depends on a lot of things, including whether they made modifications to any common elements in order to do this. Did they modify common walls, common element walls, or structure within the unit? Also, was it the current owner or a previous owner? So those are just a couple of the questions that I would want to ask a client before I then look at the governing documents for the community to try to advise a board on what it can and should do in a scenario like this. Jen, I don't know if you have other questions you would add, just sort of pieces of information that would matter to answering this question.
Just briefly, my dog was barking, so I couldn't really hear. He's right next to me.
No problem.
If you have an unauthorized modification in a unit and you're fairly certain no permits were pulled, you can call the I'm sorry, my brain isn't working. Code enforcement. Your local code enforcement agency to let them know that some work was done that may have required a permit and no permit was pulled. They may investigate, they may not investigate, it's up to them. But typically you get faster and a better response by going through a government agency rather than the association doing their enforcement process, because that takes longer. If you're worried about something affecting structure or anything that requires a permit, checking with code enforcement is generally a good place to start, and you can make a report anytime. Anyone can make a report.
Thank you, Jennifer. All right, we have another question in the chat about reserve funds as to the statute, which is, again, WUCIOA only for now, requiring that reserve funds be directly under the control of the board. The question is, can this be relegated? I think the question is, can this be delegated to the property manager via board direction? So here's my answer to this, and I'd be happy to hear, Jennifer, if you have additional thoughts on this. This is a new statute. This is new. This is not something that's been litigated, so there is not case law out there. But I don't want to be the one standing in front of a judge or making an argument that the statute says that the account must be under the direct control of the board, and that the board delegating it to a third party somehow counts as direct board control. So that's my personal opinion. I think my approach in general is low risk. I have a low tolerance for risk, which I think is one of the things that makes me a good attorney. But I do also think it's worth mentioning that we don't have case law out there that interprets this question. And so I could be wrong. And if I had a client that felt strongly that it wanted to delegate this authority to its manager, could I stand in front of a judge and make a strong and potentially credible argument that this complied with the statute? Sure. I'm not confident that that argument would succeed, but I could do it if I had a client that really wanted me to. Jennifer, what are your thoughts on that?
Honestly, there are some areas where the legislature goes a little further than we think, than maybe they should. What does direct control mean? We don't have case law or any way to interpret what that means, whether it's the board being signatories and they're the ones signing the checks and doing all of that, and then the manager just gets the invoice statements. Thank you. It's a day. So gets the statements and then just opens the account in the name of the association. We don't know.
I did just copy and paste the wording from the statute, and I do think it sheds further clarity, because what it says is it must be an interest earning account maintained under the direct control of the board, and the board is responsible for administering the reserve account.
Okay.
I think that is fairly strong wording that suggests it should not be delegated, because it clearly says the board has to administer the account, not just control it, but administer it. So I'm not saying that to argue with you, Jen, but just to sort
Well,
of provide further information in the chat.
well, and honestly, me off the cuff is not as good as reading directly from statute. So honestly, Valerie's correct. It would be a difficult, given that language, it would be difficult to argue that the reserve account was under the direct control of the board when the manager is the one who opened the account and gets the statements. So this is a new change. It's applicable to Ukiah communities now. It's not applicable to other communities yet. We don't know if the legislature is going to change this language or not, but it's something to keep in mind as January 1st, 2028 gets closer.
And I will offer that this is not one of the subjects that's currently under negotiation for the WUCIOA trailer bill that is likely to come before the legislature this year. So I think in the next 6 months, we'll know a lot more about if and how WUCIOA is going to change between now and 2028. The prime sponsor of the WUCIOA for All bill is also the sponsor of the trailer bill that's going to be coming up. And we recently learned that he does not plan to bring up any new bills going forward after this one. So we originally thought that there would be changes to WUCIOA basically every legislative session between now and 2028 as we sort of learn how it learn about its impact and tinker with some of the provisions of that statute. But unless a different legislature is willing to sort of take up the laboring oar in presenting legislation like this between now and 2028, the changes might be limited to what we see this coming legislative session. So I think that we are out of time and we've only got a couple minutes left. I do see that a new question just got popped into the chat, but if you could send that to info@condolaw.net for next week, we'll get to it then. Thank you all very much for joining us and we will see you next week. Bye, everybody.
Bye, everyone.